cash bail of Kenya shillings 50,000. Witness statements and charge sheet to issue.
He has been case since Friday.
Okay. Just liaise with the prosecution so that if it's
lakini wewe fungia sisi mpaka kotini. Wewe fungua hiyo mlango afisa. Kazi yako ni kumaintain law and order hapa. Hakuna kufungia watu wanaingia kotini. Unafungia watu kwa namna gani? Utamshika. Pana funga mlango. Kwani Kenya itakaa namna gani? Unataka kufunga mpaka koti ya mlango? Wewe ofisa na hii ni koti nani amekwambia usimame hapo? Kuna magistrate amesema usimame hapo. Kenya inakaa aje? We are all freedom fighters, aren't we? Yes. Yeah, open for the freedom fighters to access justice. Yes. Magistrate akisema tutoke, tutatoka. Lakini wewe askari hauna ruhusa ya kusimamisha watu wasiingie mahakamani. That authority belongs to the court, not you. Koti ikisema tutoke tutatoka, lakini si askari ya kuambia utoke kotini. These are public hearing. It's not being conducted in camera. Nafunga mlango, hii ni police station.
It's becoming like that, you know, the sedition. Anti-government.
We were trying to want to read it.
Yes. Right. Yes.
Precisely. Yes. To the taking of the plea. Yes. We give our reason. Secondly, a request. Council Ian Mutiso.
Present.
Council Joshua Malizo. Present, Your Honor. With Council Senator Dan Manzo.
Present, Your Honor.
We have President Emeritus of the Law Society, and Eric Feury. Thank you. That's a quorum, Your Honor. Harassment of citizens, and in this case, Rose Njeri has caught the imagination not just of the country, but the whole world. The world is calling out what's going on. Therefore, I will ask Senior Counsel Eric Feury to place on record objection to our client collective plan. Objection to our taking any plea before Your Honor. Brother Feury.
We find ourselves in a predicament. And the predicament being that the charge ought to disclose an offense known in law to enable the accused, or rather our client, to be able to take plea. Your Honor, the charge sheet that has been presented to us, in essence, gives the particulars of the offense as sending a number of emails to an email address, and the email address is provided as finance committee at parliament.go.ke. Your Honor, that email address was created by Parliament for purposes of members of the public, as our client Rose Njeri is, sending memorandums to the Finance Committee with regards to the finance bill that was being considered by the Finance Committee. And so, Your Honor, we are taken aback in terms of how do we respond to this charge when the email address was created specifically to be used by members of the public to send their memorandums either in support bill that was then being considered in Parliament. So that, Your Honor, potentially any person who sent such an can be the subject of such a charge. So not only is that charge open-ended, it fails in terms of the requirements as laid out in both Article 49 and 50 of our Constitution. And the information that is required to be provided in a charge under the Criminal Procedure Code. So, Your Honor, with that difficulty, we invite this court to decline to admit this charge. Your Honor, even as we invite this court to take the route of declining the charge that has been presented before you, that we've raised before you. Your Honor, would also be flash disks, her mobile phone, be immediately released to her. And that any information that was obtained therefrom are ideally fruits of a poisoned tree. And cannot be relied upon in this trial. Your Honor, finally, when you look at the nature of the offense that has been referred before you, you'd be hard-placed to understand why the DCI would not release our client on police terms, on police bond, having arrested her on a Friday and knowing very, very well that Monday would be a holiday by virtue of the fact that Jamhuri Day fell on Sunday. Madaraka, sorry. So in essence, that fact in itself points at the kind of malice and misuse of police powers. And at a time like this, the citizens look upon the judiciary to reset this power relationship that is being abused. And the judiciary speaks through its orders. It interrogates, as we request you to interrogate the charge sheet and to make a finding that that charge, in the fullness of time, when regimes have come and gone,
accountability inevitably always happens. And those of us who've been around for long have seen what has happened with the regime change, with radical surgery in the judiciary. And all those arise from the fact that at a particular moment in time, when such monstrous and atrocious events happen in this country, that the people kept quiet. And that the institutions which were required to ensure accountability did not live up to their billing. And that, Your Honor, we can assure the court and all of us who are here, members of the DPP, that that day will come. It might not be today because there is a regime in power that is enjoying police excesses and politicizing the police establishment to advance political purposes, but that moment will come. And when that moment comes, and I am glad that the society to which I belong to has taken a position, every other person will take a position. And then so, as I sit down to my other colleagues, we just ask the court at the back of its mind to bear and take consideration of the fact that this is not just a process where we now say there is a plea and it has to be taken. The circumstances around that fact that inform the plea have to be taken into consideration. The context has to be taken into consideration. Because if we don't take into context the consideration, a time will come when that will be done. And at that point, everyone will be asked, at this point of great difficulty, where did you stand? Did you stand at the place of convenience, or did you stand for the rule of law? Your Honor, allow me, with tremendous respect, to just place on record additional counsels that are joined us. We have Mr. Maura Kabato, the Vice President of the Law Society, and Mr. Vincent Gidaiga. We ask that you just add them to the advocates who are.
Yes. Just before I ask the Chief Justice Emeritus, who is appearing for the first time after leaving office, that in itself speaks volumes to the circumstances under which we are gathered before you this afternoon. We just want to say, as we object to taking of this plea by this wonderful heroine, a Kenyan, endowed with intellect, ability, innovation, and this is a time of innovation, we object in the strongest terms possible to the taking of this plea, and you will, we invite you, Your Honor, to withdraw and think about what Senior Counsel Theory has addressed you on. But I think it will be remiss on our part if we don't allow the Chief Justice Emeritus to very humbly, he's a man of great conscience, to be able to address you.
Thank you, Your Honor, for this opportunity. We are all here because of the nature of the allegations that have been made against Rose Njeri. We have read the charge sheet as Senior Counsel has eloquently stated. It doesn't disclose unknown events. Before you came in, we were conferring here and wondering whether Rose should be in the dock or should be somewhere where she's being celebrated for having done a wonderful job. The finance bill requires public participation. Public participation can be achieved in very many ways. And what Rose has done is to bring it to the entire public who may wish to get electronic copies to know what is in the bill. Instead of being charged, in our view, she should be applauded for having done the work of Parliament or the Parliamentary Committee and the institutions which are there to receive views. So you're not, a defective judge like this one is a worrying trend. Why do I say it's a worrying trend? Because the police will arrest, keep somebody in custody for 3-4 days, like Njeri has been kept, bring her to court, and she's taken through the motions, and at the end of the day, that charge is dismissed. She would have suffered immensely. This is what we are asking the court to stop this abuse of court process. I endorse the views of Mr. Theuri and Honorable Musyoka, that as you consider this charge and the submissions made before you, you release Njeri on our own bond. Somebody who has an address and who has had the courage of doing what she did, the police didn't need to arrest her. They just needed to call her and tell her, look, come. We want to prefer charges against you. And she would go to the police station. If there are any charges preferred against her, she would come to court and be charged. But being arrested on Friday, knowing very well that Monday is going to be a public holiday, was just meant to torture her. We pray, Your Honor, that you release her forthwith. Thank you.
Your Honor, if you, and the fact that a citizen's, young citizens' rights have been aggressed upon, allow me to invite Dr. Camino, Senior Counsel, who can never be denied the right to address the court.
Much obliged in our constitution on zero rights. From Article 19 to Article 59 of the Constitution. And that my learned friend, Mr. Theuri, has pointed out quite properly. Every advocate takes an oath before it can go. Saturday, I was in my office. I always work on Saturday. I received that call. The person spoke to me in a very solemn manner And I asked him to go to Pangani police station and see what I can do to assist this young lady, Njeri. He pointed out to me that she is anemic. He further pointed out to me that she has got little children, little minors, who have been abandoned in the house. He further pointed out to me that this lady is innocent, and he outlined to me precisely what happened. As usual, Your Honor, I dropped whatever I was doing and rushed to Pangani police. May I say, with respect to Your Honor, at Pangani police station, I met a very cooperative OCS and very cooperative deputy OCS. They made it very clear to me that there's nothing they can do for me because the lady had just been brought there by the DCI headquarters. And if I wanted any decision to be made in favor of Njeri, I had to go to the DCI headquarters. I rushed to the DCI headquarters. To my astonishment, I found nobody who could actually assist me at the DCI's office. I was told that there was an officer, senior officer, handling senior crime offenses. I tried to get hold of him. I telephoned many, many times. No one would pick up my phone call at all. As usual, I took even the courage to telephone even the director of criminal investigation himself. I was given a phone number by someone. Again, nobody would pick up my phone. Your Honor, we are living in a most unfortunate country. And I'll say to you what I said in the matter relating to Governor Natembea. Criminal law is being abused. And we can only be saved by this court. And if I may emphasize to you very respectfully what my learned friend, Mr. Tewood, has said. It is time that this court rises to the occasion and say that in view of grave violation of the human rights provision, this charge should be thrown out to the government. You bring that shock to those who are in power. Let them not take you for granted. Let them not take the law for granted. Let them not take the Bill of Rights for granted. Your Honor, we suffered for the current constitution. It reminds me what has happened in Njeri. I went to police station off Ngong Road to see whether I could get Motiba out, to see whether I could get Rukia out. Instead, I ended up by being thrown into a cell where there was already water. And I was told to remove my clothes. And I remained as naked as I came out of my mother's womb. That is now what is going on.
The rest of you is very close.
We do not want to go to those dark stages. And you can only save by the judiciary. And Your Honor, you may have noticed, I don't know to what extent you look at the newspapers, to what extent you look at the TV and so on. I have always stood by the judiciary.
No, you can never interrupt.
Notwithstanding the shortcomings that we have, I believe that it is only the judiciary that can save us from the troubles, from the issues, from the problems that are facing the country. Your Honor, we are supposed to be a democratic country. We are supposed to be a multi-party country. And just because certain people happen to be in the opposition, just because certain people are expressing positions which are expressing views which are contrary to those views of those in power, they should not be punished at all. This is what happened to Mwangi Stephen Muresi, the Deputy Director of Intelligence, whom I represented, and now he is dead. This is what happened to Matiba. This is what happened to several other people who were in power and whom I had the privilege of appearing for. That whenever they said something, those who were in power, they were punished. And we needed to have a very strong voice to stand for them. Your Honor, this time we are privileged. We have a judiciary of young people like you who can now uphold the law of the country and say to those in power, we are strong, we are independent. And the views that Njeri, whom I would say, she rises up to become like the Nightingale of the United Kingdom, who was able to stand up during difficult times to uphold the health measures in England. This young lady has done so. We must applaud her, and we must not let her down by asking her to go to the cell. To the contrary, the Honor stand up and reject this judgment. Thank you very much.
Thank you. Your Honor. Yes, Your Honor, I'll be brief and straight to the point. I adopt the submissions by my seniors, and Your Honor, today I will just simply like to speak to the heart and to the conscience of the court. Your Honor, in the case of Republic versus Mohammed Haji, therefore, any claim made against an accused person aimed at curtailing constitutional right to liberty must not be made on speculation or conjecture. Your Honor, my seniors before me have submitted as to the specifics of the charge, and I will not like to dwell on the same. However, Your Honor, the suspect was at this point in time denied a right of representation, which directly goes in breach of Article 49, 1C of the Constitution, which makes it a right for any arrested person to communicate with an advocate. She proceeded to record a statement without the presence of the advocate, and further, her personal gadgets and items, that is telephone and desktop computer, were confiscated unlawfully and illegally. Your Honor, this speaks to the threats and violations of constitutional rights of this suspect. Your Honor, just to rehash, because I have had a word with the family, the suspect indeed has 2 kids of tender age, who she has not had access since Friday. You have been told of a medical condition. Your Honor, this speaks to Article 43.1, that is the right to attain the highest attainable standard of health, and Article 43.2, which speaks on the right not to be denied emergency medical treatment. Your Honor, the right to be released on bail. Your Honor, Ibrahim J, as he was then, in the case of Republic versus Danson Ngunya and another, held that right to bail is an inalienable right. To mean, this is a right that should not be denied unless the state can prove or illustrate exceptional circumstances and or extraordinary circumstances for the denial. So, since Friday, Your Honor, she had the right to be admitted and be out, and just the way Chief Justice Emeritus had submitted, she could have been asked to present herself before this honorable court even today. So, Your Honor, as I sit, we will be praying that she be released on bond of recognition. Your Honor, the family members are present. If there is need to be a contact person, they are ready and willing to be contact person. That will be all.
Thank you. Number one, Your Honor, is that the basic issue, though there would be formal objections to these charges, is that for today we are only saying all this in order that plea is deferred today until this formal objection is made. The legal basis for why this is done, Your Honor, is that the foundation of any prosecution under the Constitution of Kenya is that the charges must be valid. And in this regard, there are at least 3 tiers that are created to ensure that the charges before the court will be valid. The DPP, admission of charges by the court, and if at those 2 stages the issue of validity of the charges is not dealt with, then under Article 27 of the Constitution and Article 50, the accused persons himself or herself, through counsel, are permitted to raise objections as to the issues of validity. And it is until that question of validity of charges is determined that any plea can be lawfully administered to an accused person. So that is to say that under the Constitution, you are permitted, in upholding the right to protection of law, to hold that, because we have signified to the court that the charges, the validity of the charges is valid, to give us another day when we can come and prosecute. That question was validity. The second question that I wish to raise is that, Your Honor, you are aware that under Article 3.1 of the Constitution, every person has an obligation to respect, uphold, and defend the Constitution. From the particulars of the offense of the charge sheet was discharging her obligation under Article 3.1 to defend the right, to defend the constitutions of Kenya, by upholding the right to public participation. We would be arguing, when the opportunity arises, that nobody can be charged with any offense in Kenya because of discharging the constitutional duty under Article 3.1 of the Constitutions to rise by way of innovations and other methods to defend the constitutions of Kenya. That is all for now.
Thank you.
When this law was made, it is common for committees of parliament to publish a notice in the newspapers and give the address of which Kenyans will publicly participate in the making of that particular law, and in the Committee of Justice, just to make sure that every Kenyan has a right, Your Honor, to public participation. And this has been an area of litigation and a lot of laws thrown out for insufficient public participation. The Law Society of Kenya is usually one of the major participants, and any other Kenyan with special intellect to participate. And Your Honor, when we made this particular law, and Section 16 was highly debated in Parliament, the intention was not to apply it the way it has been applied into these circumstances. At that particular moment, Parliament was thinking of hackers and those sort of people. They're the ones who will be prosecuted, but not a person who has been given the address, who has been given the email, and every time all those emails are done, we always bring them before the committee, they get considered, and the views of the public are taken into consideration. So, Your Honor, I do request that this particular charge does not disclose an offense, and Njeri should be released forthwith.
Thank you. Debo. Yes, thank you, Your Honor. And to urge this matter after my learned seniors have given their points, including the Emeritus Chief Justice. But permit me to refer you to Article 25 of the Constitution, which, Your Honor, protects Article 50, in the sense that Article 50, therefore, is an underogable provision of the Constitution. And that is to say, therefore, Your Honor, that it cannot be limited whatsoever and of most importance, Your Honor, is Article 50, Clause 2, Paragraph N of the Constitution. Your Honor, when the Kenyans enacted this constitution, they were aware of such kind of occurrences, and therefore they codified the common law doctrine of Nurem Crimen Sine Lege by making a specific provision in the constitution which provides that not to be convicted for an offense, for an act or omission that at the time it was committed or omitted was not an offense in Kenya. That is the doctrine of the Nurem Crimen Sine Lege that was codified.
Thank you.
That is to say, Your Honor, as I sum up, you have to interrogate this charge vis-a-vis the provisions of Section 16 of the Cybercrimes Act. When you go to Section 15, Your Honor, subsection 2, it will interpret for you what interference is contemplated. That's Parliament made this provision. For purposes of this section, an interference is unauthorized if the person whose act causes the interference is not entitled to cause that interference. Remember, the suspect, Your Honor, is here because she has responded to a public invitation through the parliamentary website that obviously expects reactions from the members of parliament. Public, Your Honor. That is therefore to ask, can that be perceived to amount to interference when Parliament has invited the members of the public to react to the finance bill? Number 2, Your Honor, you look at subsection 2, paragraph 2. Does not have consent to interfere from a person who is so entitled. By the mere fact that a publication of the website was provided to the Kenyans, there is a prima facie presumption that there is an unfettered and unexpressed consent from any member of public to send emails, be they massive emails, be they one email. Therefore, the question is, does the publication and the provisions of those websites that our client is deemed to have interfered amount to the consent by Parliament? Number 2, finally, Your Honor, look at section 57 of the Criminal Procedure Code. It gives you the power, Your Honor, to admit or to fail to admit a charge sheet. If a charge sheet does not square out in law, Your Honor, this court has the capacity under section 57 of the CPC to fail to admit. And what will inform you whether or not it discloses an offense? The particulars contained therein. If our client was to be invited to respond to the invitation by the DPP, 1, would she be sufficiently be informed to understand the cause of the offense that she's pleading to? Does it disclose an offense? Do the particulars disclose an offense sufficiently enough to inform our client whether to answer to a charge of guilty or to a plea of not guilty? Finally, Your Honor, this charge that has been brought before you must be read in the light of public policy, in view of what the country is currently anticipating. That the state is at the verge of introducing a punitive finance bill, and they do not want the members of public to react to it. Finally, Your Honor, read this charge sheet in view of Article 10 of the Constitution, as well as Article 118 of the Constitution, where the Constitution has directly invited members of public to participate in the legislative process. If you admit this charge as it is, Your Honor, it will amount to you violating the provision of the Constitution where members of public are actually supposed to participate in a process. So the admission of this charge will act as a clawback to the constitutional gains that the country has attained. I am most humbled.
To act as the last line of defense for the citizens of this country. Therefore, we submit.
Charges and what the court should do to determine whether or not the charges any charges before it are proper or improper. The jurisdiction of this court is given in addition to the Constitution by the Magistrates Court Act 2015, which gives the court jurisdiction, some limited jurisdiction to enforce questions of alleged breaches of fundamental rights and freedoms, very limited under Section 8.2. Whether that act or statute gives the court jurisdiction to hear criminal cases, including the one proposed to be instituted by the charges, the impugned charges before you. To address the question of Section 8.2, Your Honor, there has been reference to Article 43, for example, 43 of the Constitution. There's been reference to Article 31. There's been reference to Article 27. All those provisions of the Constitution are beyond your jurisdiction. And I love the laughter. The jurisdiction of this court to enforce fundamental rights and freedoms under Section 8.2 is limited to Article 25A and B of the Constitution. It is explicitly written there. Having said that on your jurisdiction, coming to the charges, Section 89, subsection 5 of the Criminal Procedure Code is the relevant provision before you this afternoon. 89, subsection 5. That this court can reject charges. Allow me to read, just refer to my phone in a minute. Sorry, Your Honor, I'll take a minute. With complaints and charges says, where the magistrate is of the opinion that a complaint or formal charge, as the one we brought before you, made or presented under this section, does not disclose an offense, the magistrate shall make an order refusing to admit the complaint or formal charge and shall record his reasons for the order. One of the arguments that the defense have made is that there is no offense known in law disclosed by the charge sheet before you. And Your Honor, therefore, I will invite the court, let us have a look at Section 134 of the Penal Code. Sorry, of the Criminal Procedure Code. CPC says, every charge or information shall contain and shall be sufficient if it contains a statement of the specific offense. And let me just have a copy of the charge sheet, Counsel. A statement of the specific offense. So I'll read this section vis-a-vis the charge sheet. This is Section 134 of the Criminal Procedure Code. The statement of the offense in count 1 is unauthorized interference with the computer system. Statement of the offense. So that is in line with Section 134. And it goes ahead to say, if it contains a statement of the specific offense or offenses with which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. So we can easily answer the first part. The statement of the offense is available in both count 1 and count 2. It's the same. That offense is said to be in contrary to Section 16 of the computer misuse for both offenses. Now let us look at the particulars of the offenses. The requirement by law, at least by statute, which gives the argument, is that it should give information as to the nature of the offense. And the information that is given is that the accused person, the suspect before you, knowingly made a program hosted at that website that automatically generated and sent mass emails. Is there sufficient information to understand what we are alleging you to have done? The answer is easily yes. So is there an offense known in law? Section 16 creates this offense. Now, Your Honor, there's the argument as to whether Parliament may have intended that the acts we are alleging to have been done amount to an offense. That is a triable issue. And the Honorable Manzo can be a very good defense witness because he will tell us what they intended as Parliament not to be an offense. But as far as Section 134 requires us to give particulars, we have given the particulars. Whether or not we are able to prove these charges or the defense will lodge our charges is an issue for trial. So that, Your Honor, in summary, what we are telling you is that your jurisdiction in response to the questions raised by the defense is limited to Section 89(5). Read that together with Section 134, both of the Criminal Procedure Code. If you find that the prosecution in the charge sheet has given reasonable information, then you cannot reject the charges. You have not been told that the charge is defective because it is duplex. No one has told you that. So is there a charge, is there an offense known in law? Yes. Are the prosecution able to prove it? That is a triable issue. We cannot deal with it. It cannot be the basis of rejecting the charges. So, Your Honor, like I promised today, I wanted to go very short on this. There have been issues of alleged violation of rights. We really sympathize with the defense and the suspect. We have no reason to doubt them. But, Your Honor, we are saying that because the jurisdiction of this court is given by the Constitution and statute, and that because there cannot be a violation of a right without redress, that redress is available, but not before you. And there are very many appropriate reliefs under Article 23 of the Constitution. Those reliefs, by dint of Article 165 of the Constitution, are vested in the High Court of Kenya, which has the power and jurisdiction to hear and determine questions of alleged violation of rights. You know, we submit that with that small submission, our charges are proper, and in the words of my friend, Mr. Mango here, or is it Mr. Kibe Mungai, the charges are valid. Oh, Mr. Kibe Mungai. The charges are not only proper, but they are valid. Whether or not they will be proved is a question for trial. As I conclude, we reiterate that we are not opposed to the release of the suspect on bail. Thank you, Your Honor. I'm privileged to appear before you.
Whether or not this interference was authorized.
Yes, I just want to restrict myself. He is going to take any other issue that arises. Your Honor, I think we had made it very clear, my learned colleagues misunderstand the thrust of what we are saying for purposes of today. Because issues to do with validity of charges have arisen. The key prayer was we seek deferment for the taking of plea so that a date may be reserved for us to prosecute our case concerning the issue of validity of charges. Because as we have said, under the 2010 Constitution, she expected protections from the DPP. None appears to have come from the DPP. Before her appearing before you, before registering these charges, she also expected that unless they are on the face of it, prima facie, there was something that was apparent that an offense has been disclosed, she couldn't be brought again to court. But now that we have reached here, Your Honor, the accused person herself says that I object to taking plea on account that the charges are not valid. Whatever will become of that can only take place after we've been given that opportunity, and that is where we started from, to raise those issues elaborately with all the authorities that are relevant to the issue. Be that as it may at this stage, Malana's colleague has referred
maybe just guide us
of Section 89(5) of the CPC. Section 89(5) of the CPC on the issue of admission of charges. Your Honor, the jurisdiction is given by this court to determine the questions of validity. The questions of validity, because Kenya has a written constitution that is required to be enforced by all courts exercising powers under the constitution, must be addressed if it is made. And it is towards this that we are saying, for purposes of this section 89C, this charge cannot be valid on the face of it because the particulars directly relates to the fact that what the accused person is accused of is actually the performance of something that the citizens are required to do, both under Article 10, Article 3, and 116 of the Constitution. 118 of the Constitution. So those particulars read together with the charge cannot be able to disclose an offense that is admissible for purposes of Section 89C of the CPC. The last point that I wish to make under Section 134 of the Criminal Procedure Code is a question of reasonable information. The term reasonable information must be understood in the context that that reasonable information is information that discloses an offense. And we are submitting that on the face of it, the information stipulated in the charge sheet.
Can I look at the charge?
Does not disclose an offense, and on the contrary, what it discloses is that you engage in activities required of you as a good and patriotic citizen of the good Republic of Kenya. So if that be the case, then there can be nothing in the particulars that can support the charges. Therefore, it is my submissions that either under Section 89.5 or 134 of the CPC, it would be within your jurisdictions to hold that there are no valid charges before this court to commence what is clearly an oppressive prosecution that violates the constitutions in such an obvious and unfortunate way. We are most obliged.
Reading of the charge before you is that the suspect, who is our client, is being charged using an email for the purpose for which it was created.
Yeah. Simple as that.
So the public were invited to send memorandums. An email for that purpose was created. And emails for that purposes were sent. So what we are saying is that potentially any person who used that email for that purpose can be charged for the offense which is before this court. And we are saying, in that respect, there is no sufficient information to enable our client to respond to the charge. Secondly, Your Honor, and I love what Mr. J.V. Owiti did in his very elaborate style. He did quote for you the provisions of the law. And so, Your Honor, the question then becomes, how do you arrive at the opinion that the charge either discloses or does not disclose sufficient particulars? You must examine the charge. And that is what we are inviting you to. And my Lord, Your Honor, and perhaps those are blessings for you. it cannot be said that when questions of obvious violation of the Constitution arise, that this court will be told, you have no jurisdiction. To the contrary, you actually have jurisdiction. The only thing that you cannot do is to perhaps give redress for the violation of those constitutions, of those rights, in view of damages. But the court must take into account those violations as it is looking at or trying to arrive at a conclusion whether sufficient information has been given or not. Because the circumstances of an arrest, it tells a story. So obviously, the prosecution will tell you, you have no jurisdiction, don't look at, and we actually, I do agree with that, but we are telling you, consider those circumstances. They are relevant. They point to malice. What again have the police done? Illegally seized communication gadgets from our client. That illegality must be brought into the mind of the court. Why would they do that? And we need to get to a point where we will bring civility in the manner in which we handle the criminal process. And the only way, Your Honor, unfortunately, is that the court must speak to this. And the reason why the Constitution requires this court to look at all those circumstances is because of our checkered history. We have some directors of public prosecution whose children do not even want to bear their name because of the regime of repression that they perpetrated. And that history, and you all know that when it comes to interpreting the Constitution, the history of the country is extremely important. And that is why the circumstances surrounding this, because they point to a history that the Constitution wants us to move away from, must be taken into consideration as the court weighs on the question of whether there is sufficient information or otherwise in this.
Okay. Sorry, Your Honor.
And so,
without interjecting, Mr. President, allow me to interject. Your Honor, I was only going to plead with the counsel through court that this is a rejoinder. And a rejoinder should be on points of law without going, I understand.
Indeed.
And I agree with him, and what I wanted to say is that at a time like this is also a political trial. Yes. In the fullness of time, this is a political trial because it is an egregious violation of someone's rights. And the context politically must bear on this.
Okay.
And that is why these statements must be made. They might be not for this court, but they must be made, and that has always happened in any political trial. Okay. And I know it makes them uncomfortable because we are reminding them of a reality.
May the court guide us. You know, some of us from the prosecution politically, like President, please guide us so that we do not go to a route where we don't have an ability to respond to. I cannot respond to those political remarks. I am a prosecutor of the state. He has a right to make political remarks. There is unfairness there. So because we are in rejoinder, let him stick to the rejoinder. He can give me these political remarks outside where I may be able to joke about them.
That's fine. You're and of course it was not meant for you. It was meant for another audience elsewhere. But that said and done, Your Honor, I think in terms of the rejoinders, we will speak to that and invite.
Thank you. Finally, we started by inviting you not to accept the taking of a plea in the instant case. And when it comes to application of Bill of Rights, Article 20, Your Honor. The Bill of Rights applies to all law and binds all state organs and all persons. So it cannot be argued that this court lacks the jurisdiction. This is absolutely vital. And then again, simple issue, which we invite you now finally consider whether this charge is not an abuse of the court process. And therefore, you have the jurisdiction just to throw it out, taking into account the grave nature of this matter of Rose Njeri. I started by saying that it is not a matter just for this country, but international. All the international human rights organizations are watching. It has been argued by my learned colleagues here, including CJ Emeritus. And what would you say about JBC, about jurisdiction, when you have the immediate former Chief Justice sitting here and putting this matter? So, Your Honor, simple article, the charge is brought under Section 16 of computer misuse and cyber crime. When Rose was invited to interfere for this public participation, now they're changing the whole thing, interference, to mean she's committing a cyber crime. If a crime is sensitizing our fellow Kenyans to say yes or no to the proposed finance bill, what crime is that? Therefore, we invite you, Your Honor, to just throw this matter out, and you'll be making history. We can tell you that. We beg.
Submissions by counsel for the suspect and the response by the prosecution counsel. The suspect herein, Rose Njeri, is hereby granted a personal bond of Kenya shillings 100,000 plus one contact person. The ruling will be delivered on 20th of June at 10:30. 10:30. Let's call that on the next one. Next matter.
Criminal case number 8314 of 2025, Webster Ochoa Elijah.
Just a minute.